I never lied to them. I just never corrected them. When Diane asked me what I did for a living at that first dinner, the one with the good china and the bad intentions, I said office work. She nodded and turned back to her salmon. That was the end of it. No follow-up, no curiosity. I was already filed away in her mind as something small, and small things don't require further examination. What I didn't say that my office has a seal of the United States on the wall. That when I walk in, everyone stands. That the word I speak last in any room is the word that counts. I kept that to myself for 3 years. By the time they finally saw me, really saw me, it was too late to pretend the version of me they'd invented was the real one. I want you to understand something before we go any further. I wasn't hiding because I was ashamed. I was watching. There's a difference. And what I saw told me everything I needed to know about what was coming. Before we go any further, what time is it where you are right now? Drop your time and your country in the comments. I want to know who's here for this. The night I met Marcus, I was wearing a $34 dress from a clearance rack in Decatur. That detail matters. Not because of the price. I had a closet full of things that cost more, but because of the choice. I'd been on the bench for 4 years by then. I knew what it felt like to walk into a room and have it shift around you. I knew what happened when people knew your title before they knew your name. So when my colleague Donna invited me to that fundraiser at the Piedmont Room, I made a decision. No title, no introduction, just Skylar. I wanted one night where someone talked to me like I was a person and not a position. Marcus found me by the window. He was easy to look at, broad shoulders, a laugh that came from somewhere, real, a way of listening that made you feel like the room had gotten smaller in a good way. He asked what I was drinking. I said sparkling water. He said he respected that at an open bar. I laughed. It was the first genuine laugh I'd had in 3 weeks. We talked for 2 hours without exchanging business cards. He told me he worked in real estate development. Family business, he said with a particular kind of pride that told me the family had built it from something real and had never quite let go of that origin story. His mother Diane had started it. His younger sister Renee handled the marketing. He was the one who brought in new clients, closed deals, kept the machine moving. He said it like it was a calling. I found that attractive. I still believe in people who take their work seriously. What I didn't find out until much later was what kind of deals he was closing. And how. We had dinner the following Saturday at a small Ethiopian place on Edgewood that Marcus had to look up directions to because it wasn't in any of the neighborhoods he usually moved through. That told me something too. He was willing to go somewhere unfamiliar. I filed that away as a good sign. I was still building my case for him, then still looking for evidence that he was who he appeared to be. On our third date, he asked again what I did. I told him I worked for the federal court system, which is true. I do. He nodded like that meant I was a clerk or a paralegal or something administrative and quiet that didn't require further inquiry. I didn't correct him. I watched him decide what I was, and I let him. Not because I was playing a game, because I needed to know if the version of me he was choosing, the version without the title, without the robe, without the courtroom, was enough for him. For a while, it seemed like it was. We dated for 11 months before he introduced me to his family. 11 months of Saturday mornings, and long drives out to Stone Mountain and arguments about which Atlanta neighborhoods were actually changing versus which ones just thought they were. 11 months of building something that felt, on most days, like it could hold weight. The introduction happened at Diane's house in Buckhead. 5 bedrooms. A kitchen that had been renovated twice in the last decade. A driveway with 3 cars, one of which was purely aesthetic. I wore a blue wrap dress and brought a sweet potato pie I'd made myself because I didn't know what else to bring, and baking steadies my hands when I'm nervous. Diane opened the door, looked at the pie, and said, "Oh, how sweet." Then she turned to Marcus and started talking about something else. Renee was polite in the way people are polite when they've been told to be. She asked where I was from. I said I grew up in Savannah. She said, "Oh, lovely," and reached for her phone. Dinner was a performance. The family had a rhythm. I wasn't part of a series of inside references and overlapping sentences that functioned less like conversation and more like a demonstration. Marcus was fluent in it. I sat beside him and watched and ate the green beans and answered the questions they asked me, which were mostly logistical. Where did I live? Did I own or rent? What part of Atlanta? Nobody asked what I did again. Diane had already decided. After dinner, Marcus helped his mother clear the table, and I stood at the kitchen doorway and heard Diane say in a voice calibrated to carry just far enough, "She seems fine. Just quiet." Fine. Just quiet. I thought about that on the drive home. I thought about the last brief I'd written, 41 pages that 3 federal agencies had used to revise their intake procedures. I thought about the sentence I'd handed down the previous Thursday that a team of 6 lawyers had spent 8 months trying to influence. I thought about what it means to be the last voice in a room. Fine, just quiet. I decided that night that I would let Diane keep her version of me. It cost me nothing. And I had learned a long time ago that the people who underestimate you are doing you a favor they don't know they're giving. Marcus reached over at a red light and put his hand over mine. "They liked you," he said. I looked out the window at Peachtree Street moving past in the dark. "I know," I said. The first sign was a sound, not a conversation I wasn't supposed to hear. Not a text message left open on a counter. Just a sound, the specific careful click of a door being pulled shut by someone who didn't want it to make noise. Marcus had never closed the door to his home office before. In 3 years of weekends at his place, that door had always been open. It was open when he took work calls, open when he reviewed contracts, open when he argued with Renee about the Marietta project that had gone sideways in the spring. Then, one Saturday in October, it was closed. I was in the kitchen making coffee. The Breville was loud, so maybe he thought I wouldn't notice. But I noticed things. It's not a skill I developed for the courtroom. I was doing it long before I ever put on a robe. My mother used to say I was born with a legal pad in my head, always taking notes, always filing things under the right tab. She meant it as a complaint. It turned out to be a career. I finished making the coffee. I brought him a cup. I knocked and waited. He opened the door after a beat too long. The laptop was angled away from me. Not closed angled. That's a specific choice. Closing it would have looked obvious. Angling it was supposed to look casual. It wasn't. "Thanks, babe," he said. He took the cup. He kissed me on the cheek. He went back to the desk. I went back to the kitchen and stood at the window and looked out at the backyard and drank my coffee and noted the time. 9:14 a.m. Saturday, October 11th. I noted the behavior. I noted what it meant and what it might mean, and what I would need to see before I was willing to decide between the two. That's the thing about training your mind to weigh evidence. You stop reacting to single data points. You wait for the pattern. The pattern came in pieces over the following 6 weeks. A Saturday in mid-October, when Marcus said he was meeting a client for lunch and came home 4 hours later with no mention of the meeting. No name, no deal detail. Marcus always talked about his deals. That was part of who he was, the story of the close, the handshake, the thing he'd seen coming that nobody else had. When he stopped talking about a meeting, it was because there was something about it he didn't want to narrate. A Thursday night when I called at 7 p.m. and he didn't answer. Called back at 7:40. He picked up and said he'd been in the gym. I asked which one. He said the one on Piedmont. I knew the one on Piedmont closed at 7 on Thursdays because I'd tried to go there the previous February and found a sign on the door. I didn't say that. I said, "Oh, okay. What do you want for dinner?" He said, "Whatever you feel like." I made pasta. I set the table. He came home at 8:15 and ate, and told me about a property in Alpharetta that he was close to acquiring. And everything was normal and easy, and I sat across from him and listened and watched the way he held his fork and thought about evidence and patterns and what it means to know something before you can prove it. The receipt was a Tuesday in November. I wasn't looking for it. That's the part I want to be clear about. I was not going through his things. I was putting away laundry, his laundry, which I had offered to do because I was already running a load. And it made logistical sense, and the receipt fell out of the inside pocket of his sport coat. It floated down and landed face up on the bedroom floor like it had somewhere to be. Restaurant Eugene. That's a $200 a head restaurant on Peachtree Road with low lighting and a wine list that takes up 4 pages. Date Friday, November 3rd. Time 8:47 p.m. Party of 2. On Friday, November 3rd, I had been at the federal courthouse until 9:15 p.m. finishing a sentencing memorandum. Marcus had texted me at 6 that he was ordering in and watching the game. I stood in the bedroom holding the receipt for a long time. Then I folded it exactly as I'd found it, slid it back into the pocket, finished putting away the laundry, and went to the kitchen to start dinner. I want to explain what happened in my body in that moment because it wasn't what you might expect. It wasn't the dropping feeling of betrayal. It wasn't tears. It was something older and quieter than that, a kind of settling. The way a courtroom goes still when the last piece of evidence has been entered, and everyone in the room understands without being told that something has just shifted permanently. I had enough to build a case. I just wasn't ready to try it yet. Marcus came home that evening with flowers. Grocery store flowers, the kind wrapped in plastic with a rubber band around the stems. He put them in the blue vase on the counter and said he'd seen them and thought of me, and I looked at the flowers and then at him and said they were beautiful. They were carnations. I don't particularly like carnations, but I put them in water, and I went to bed. And I stared at the ceiling in the dark, and listened to Marcus breathe beside me, and thought about Restaurant Eugene, and a table for 2 and a Friday night. And all the things that had been happening in rooms I wasn't in. I thought not yet. I thought, but soon. Diane's birthday party was a catered event. That should have been the first thing I noticed, not about Marcus, not about Amber, but about the family itself. A birthday party with a catering company and a rented tent and a jazz quartet in the backyard is not a celebration. It's a statement. It says, look at what we have built. Look at what we can afford to do on a Tuesday evening in December, just because we feel like it. Diane had turned 64. She was being celebrated like a head of state. I wore a burgundy dress I'd had for 2 years. Modest neckline, knee length. Nothing that asked for attention. That was intentional. I had learned early that the way to move through the Whitfield family events without friction was to give them nothing to comment on. No jewelry that invited comparison. No dress that made Renee adjust her posture. Just Skylar, quiet and fine, standing near the hydrangeas with a glass of sparkling water. Marcus was working the room. That was his natural state at these events, moving from cluster to cluster, hand on shoulders laugh, arriving just before the punchline, making everyone feel like they were the most important person he'd spoken to all evening. I had found that quality magnetic once. That night, I watched it from a distance and thought about what it costs to perform warmth for a living. I was standing near the back of the tent when the gate opened. She came in with the ease of someone who had been there before. Not to this party, I would have remembered her, but to spaces like this. She knew how to enter a room that wasn't hers and make it feel like it was. Late 20s, golden caramel skin, long black hair loose past her shoulders, a green dress that had been chosen carefully to look like it hadn't been chosen carefully. She was carrying a small gift bag with tissue paper that matched the dress. I watched Marcus see her from across the tent. I want to be precise about what I saw because precision matters. He didn't react the way men react when they see a colleague or a family friend. There was no wide public smile, no arms open greeting. Instead, he went very still for exactly 2 seconds, and then he recalibrated, adjusted his expression, excused himself from the conversation he was in, and moved toward her at a pace that was designed to look unhurried. They did not hug. That's the detail that told me everything. 2 people who are only colleagues hug at a party. 2 people who are more than that have already agreed without saying so that they won't. He brought her over 20 minutes later. "Skylar, this is Amber. She works with our firm on the Alpharetta project." Amber smiled. It was a good smile, practiced pleasant, designed to land without leaving a mark. She said it was so nice to finally meet me. She said Marcus talked about me all the time. I said it was nice to meet her too. I held out my hand and she shook it, and I noticed on her right wrist a thin gold bangle with a small hammered disc pendant. Delicate, specific. The kind of thing that gets chosen, not grabbed. 6 months earlier, Marcus had told me he'd lost a bracelet I'd given him for our first anniversary. A thin gold chain with a small hammered disc pendant. He said he thought it had slipped off at the gym. He'd seemed genuinely upset. I had told him it was fine. It was just a thing, things get lost. I looked at the bracelet on Amber's wrist. I looked at Amber's face. I looked at Marcus, who was already turning towards someone else, already moving on, already performing the next version of himself for the next cluster of guests. I took a sip of my sparkling water. Renee was standing 6 feet away. I know because I felt her look at me at the exact moment I noticed the bracelet. Not a glance, a look. The kind that checks to see if you've understood something. When I turned toward her, she held my gaze for 1.5 seconds and then looked down at her phone. She knew. She had known, I realized, for a while. I spent the rest of the evening at the party doing what I do in any room where I need to hold myself together, I observed. I cataloged. I noted who spoke to Amber and who avoided looking at me when they did, which family members laughed a little too easily when she made a joke. I noted that Diane touched Amber's arm twice during the evening, with a particular warmth she had never once directed at me. I noted that Amber knew where the extra napkins were kept. She had been to this house before. At 9:47 p.m., I told Marcus I had a headache and was going to call a car home. He said of course he'd be home by 11. He didn't want to leave his mother's party early. I said I understood completely. I kissed him on the cheek. I said goodnight to Diane, who said, "Feel better, sweetheart," in a voice that told me she was relieved I was leaving. In the car, I sat in the back seat and looked out the window at Buckhead moving past. And I was very quiet and very still, and the driver didn't say anything. And I was grateful for that. I thought about the bracelet. I thought about Renee's look. I thought about the way Diane had touched Amber's arm. And somewhere on 85 North in the dark between one exit and the next, something in me made a decision that my mind hadn't fully caught up to yet. Not anger, not grief. Something cooler and more durable than either of those. I had spent 11 years learning how to build a case that holds. I knew exactly what I was going to do. The morning after Diane's party, I woke up at 5:47 a.m. and made coffee and sat at the kitchen table with a yellow legal pad and wrote down everything I knew. Not everything I felt, everything I knew. There's a discipline to that distinction that took me years to learn. Feelings are data, but they're not evidence. They tell you something is wrong before your mind can articulate what. But you can't build anything durable on feeling alone. You need facts, dates, specifics. The kind of thing that holds up when someone looks at it under fluorescent light and asks you to prove it. I wrote for 40 minutes, When I was done, I had 2 columns. The left column was facts. The right column was what those facts suggested. I looked at the right column for a long time. Then I folded the paper in half, put it in the inside pocket of my work bag, and went to get dressed. Marcus was still asleep. I stood in the doorway of the bedroom for a moment and looked at him. He was on his stomach, face turned away, one arm hanging off the side of the mattress. He looked peaceful. That used to be one of my favorite things about him, the way he slept, without apparent guilt, like a man who had made his peace with every decision he'd ever made. I had found that quality restful once. I went to work. The first call I made that morning was not to a divorce attorney. It was to my financial advisor, a woman named Patricia, who had been managing my accounts since I was an assistant DA making $58,000 a year, and had the discipline to put away $400 a month anyway. I told Patricia I needed to review the structure of our joint accounts and make sure my personal assets were clearly delineated. I told her I was doing some estate planning. Patricia has known me for 15 years. She said, "Of course," and asked no further questions, which is one of the many reasons I've kept her. The second call was to a colleague who specialized in family law, not because I needed a referral. I knew every family law attorney in Atlanta worth knowing, but because I wanted to have a conversation that was off the record and informal, and allowed me to understand my position without filing anything, without creating a paper trail, without doing anything that could be characterized as preparation. My position, as it turned out, was strong. What Marcus did not know, what none of them knew, was that I had been careful from the beginning. Not because I anticipated this. I want to be clear about that. I had not married Marcus expecting it to end. I had been careful because I had watched too many people, smart people, careful people, people who should have known better lose everything in a divorce because they had been careless during the marriage. Joint accounts where everything was commingled, property titled incorrectly, retirement funds touched for things they shouldn't have been touched for. I had seen it from the bench. I had seen it in the lives of people I respected. I had decided early that I would never be that person regardless of how the marriage went. So my accounts were mine. My property was titled correctly. My retirement accounts had never been touched. The house we shared was in both our names, yes, but the equity calculation was not complicated. I was not starting from zero. I was starting from exactly where I had always been. That week, I continued living my life with a precision that I think in retrospect was its own kind of power. I went to court every morning. I ruled on motions. I wrote opinions. I had lunch with my clerk, a 26-year-old named Jordan, who was going to be an extraordinary attorney in about 5 years if he didn't let anyone talk him out of his instincts. I went to the gym on Tuesday and Thursday. I called my mother on Wednesday evening, as I always did, and talked to her for 45 minutes about her garden and her neighbor's new dog, and a book she was reading about the civil rights movement in Savannah. I did not tell my mother what was happening. Not yet. My mother would want to respond immediately and dramatically, and I loved her for that, but drama was not what I needed. I needed stillness. I needed the particular clarity that comes from having decided something and not yet having acted on it. Marcus, during this time, performed the role of attentive husband with what I can only describe as commitment. He made dinner twice. He suggested we see a movie on Saturday, something he hadn't proposed in months. He asked about my cases carefully, generally the way people ask about work when they want to seem interested without actually engaging. He touched my hand across the table at dinner. He said one evening when we were watching television that he felt like we hadn't really talked in a while and maybe we should plan a trip somewhere. I said that sounded nice. I was watching him the way I watch a witness who has just been informed that the opposing counsel has new documents. The behavior changes. The performance intensifies. The attention that was absent suddenly floods back in, too warm, too available, slightly off tempo. Marcus was performing attentiveness at me, and it had the texture of something rehearsed. I received it. I did not reciprocate or reject it. I simply received it and noted it and filed it. On Thursday of that week, I stayed late at the courthouse after everyone had gone. I sat in my courtroom in the dark, not in my chair, just in the gallery, one of the long wooden pews where the public sits. I do this sometimes when I need to think. There's something about sitting in the room without the authority of the bench that clears my head. I'm just a person in a room. The room doesn't care who I am. I sat there for an hour. I thought about the bracelet. I thought about Renee's look. I thought about 11 months of building something and 3 years of living inside it, and whether the thing I had built had ever been real, or whether I had simply been a careful architect working with materials that were already compromised. I thought about the yellow legal pad in my bag. I thought about what came next. By the time I stood up and put on my coat and walked out of the courthouse into the cold Atlanta night, I had made 2 decisions. The first was practical. The second was the kind of decision that once made cannot be unmade. I drove home. Marcus was awake watching film on his laptop. He looked up when I came in and said he'd saved me dinner. I said thank you. I heated it up and ate it standing at the counter because I wasn't ready to sit across from him yet. He didn't notice, or if he did, he didn't say so. I washed the dish, I dried it, I put it back in exactly the right cabinet. And I thought, he has absolutely no idea who he is living with. The exclusions began in January. That's the word I use for it now, exclusions. Not slights, not rudeness, not the passive aggression of people who want you to feel small, but don't want to be caught doing it. Exclusions. Deliberate, coordinated, and executed with a particular confidence of people who have decided that the outcome is already settled. It started with the family group chat. I had been added to it 2 years into the marriage, a concession I understood more than a welcome. The chat was called Whitfield Family, and it was mostly logistical. Diane's doctor appointments, Renee's son's school events, Marcus relaying information about the business. I rarely participated. I read it the way I read most things, for information, not for connection. In January, I noticed I was no longer receiving the messages. Not removed, that would have been too direct, too accountable. The chat had simply been recreated under a new name with the same members, -1. I only knew because Renee mentioned a conversation about Diane's upcoming medical procedure at a family dinner I had still at that point been invited to, and I had no idea what she was referring to. I checked my phone, checked the old chat. Nothing new since December 28th. I said nothing. I noted it. The dinner invitations became irregular after that. Diane had a Sunday dinner tradition that Marcus had described to me early in our relationship as non-negotiable. For 3 years, I had been there nearly every Sunday, eating Diane's food, sitting in Diane's dining room, performing the role of daughter-in-law, with the same quiet consistency I brought to everything. In January, I was not invited 2 Sundays in a row. Marcus went alone both times. He said his mother wasn't feeling well the first time. He said it was a small family thing the second time. He said it the way people say things when they know the explanation doesn't hold, but they've calculated that you won't push back. I didn't push back. I made a note. Renee posted a photo on a Friday evening. Instagram. A dinner table. Diane's dining room. I recognized the chandelier with 6 people around it, all laughing mid-conversation, the particular warmth of a group that is entirely comfortable together. Amber was in the photo. She was seated in the chair that for 3 years had been mine. She was laughing at something Marcus had said. Her hand was near his on the tablecloth. Not touching. Near. Renee had tagged it family dinner. That was the caption. Just that. I looked at the photo for 11 seconds. Then I put my phone face down on the desk and finished the motion I was reviewing. Marcus came home that night at 10:30. I was already in bed reading. He moved around the room quietly in the way he did when he was hoping I was asleep. I kept reading. He got into bed and said good night, and I said good night, and he was asleep in 8 minutes. I read for another hour. The request for space happened on a Wednesday. We were in the kitchen mourning, both of us getting ready for our respective days. Marcus was making a protein shake. I was reviewing notes I'd brought home from Chambers. Normal morning architecture. Then he turned off the blender and said without looking at me that he'd been doing some thinking. And he felt like we'd grown in different directions. And he thought maybe he needed some space to figure out what he wanted. He said it the way men say things when someone else has written the script. Too even, too rehearsed. The syntax of a speech practiced in a car. I put down my notes. I looked at him. I said, "What kind of space?" He said he wasn't sure yet. He said he cared about me. He said this wasn't about anyone else. He actually said that those words, "This isn't about anyone else." And something in my chest went very flat and very cold. Because the specific choice to say that particular sentence without being asked is its own kind of confession. I said, "Okay." He blinked. He had expected something else. Tears maybe, questions. The particular turbulence of a woman who doesn't know her position. He got one word delivered in a register so neutral, it had no surface for his expectations to land on. "Okay," I said again. "Let me know what you decide." I picked up my notes. I finished my coffee. I left for work at 7:43 a.m., which was my normal time, and I did not cry in the car. And I did not call anyone. And I did not alter my route or my speed or my radio station. What I did was think. I thought about the exclusions, the chat, the Sunday dinners, the Instagram photo with a caption that said family in a chair that had been mine. I thought about the bracelet. I thought about Restaurant Eugene. I thought about 3 years of being filed under fine, just quiet by a woman who had never once asked what I actually did for a living. And I thought about a case that had landed on my docket 6 weeks earlier, a civil fraud case, real estate. Multiple LLCs, layered ownership structures, properties in Fulton and Cherokee and Forsyth counties. A plaintiff who had been defrauded of $2.3 million in a development deal that had promised returns it was never designed to deliver. The defendant entity was a company called Whitfield Premier Development Group, LLC. I had flagged it immediately and disclosed the potential conflict to my chief judge. I had offered to recuse. My chief judge had reviewed the disclosure, reviewed the nature of my relationship to the defendant entity's principals, and had made a determination the connection was tangential enough. And the recusal motion had not been filed by either party. And the case could proceed. I had accepted that determination. What I had not done, what I would never do, what 11 years on the bench had made structurally impossible for me to do, was allow a personal situation to influence how I handled a legal matter. The case would be decided on its evidence, on its law, on the facts as presented and the standard as written. Marcus didn't know the case existed. He didn't know because he didn't know what I did. He came home that evening and said he thought it might be best if he stayed at his mother's for a few weeks, just to have some clarity. He'd already packed a bag, he said. It was already in the car. He was already halfway out the door before he told me he was leaving. I said, "I hope you find what you're looking for." He looked at me for a moment with an expression I couldn't quite read, something between relief and a flicker of something else. Something uneasy, the way a person looks when the room doesn't react the way the room was supposed to react. Then he left. I locked the door behind him. I stood in the hallway for a moment in the silence of the house. And then I went to my study. And I sat down at my desk. And I opened the Whitfield Premier Development Group case file. and I read for 3 hours without stopping. I was not doing anything wrong. I want to be precise about that. I was doing my job. I was doing my job with the same rigor and neutrality I had brought to every case for 11 years. The facts of the case did not change because of what was happening in my personal life. The law did not change. My obligation did not change. What changed was that I finally understood, sitting at that desk in that silent house, why I had been so careful for so long about everything. The robe and the life beneath it were two separate things. They always had been. But they were about to be in the same room. The document that changed everything was 43 pages long and smelled like a copier that needed its toner replaced. I know that detail is strange to remember, but I remember it because I was sitting in chambers at 7 a.m. on a Tuesday in February when my clerk Jordan slid the filing across my desk and said quietly that I should probably look at this before the morning docket. Jordan had been with me for 2 years. He did not use the word probably lightly. I put down my coffee and picked up the filing and read. The plaintiff's attorneys had submitted a supplemental evidence package, 43 pages of internal communications, wire transfer records, and a series of LLC formation documents that had been obtained through discovery. The kind of paperwork that looks bureaucratic and tedious until you understand what it's describing, and then it stops looking tedious entirely. What it described was a pattern. Whitfield Premier Development Group had been raising capital from investors for a series of residential development projects across the northern Atlanta suburbs, Alpharetta, Cumming, Canton. The pitch was consistent premium developments, pre-sold units returns of 18 to 22% over 36 months. The investors were not institutions. They were individuals. A retired school principal from Marietta who had put in $340,000. A family from Duluth who had invested $580,000 from the sale of a business. A 71-year-old man from Roswell who had written a check for $410,000 and told his daughter it was going to be his legacy for his grandchildren. The money had gone in. The developments had not materialized. What the internal communications showed: emails, text chains, a series of voice memos that someone had been foolish enough to transcribe, was that the principals of Whitfield Premier had known from the beginning that at least 2 of the projects were not viable. The soil reports for the Cumming site had come back problematic in early 2021. The Canton permits had been denied twice before the investors were brought in. The Alpharetta project, the one Marcus had told me about over dinner, the one he described as the most exciting thing the company had done in years, had a title defect that made development legally impossible until a court proceeding resolved a competing claim. They had known. They had raised the money anyway. I read all 43 pages without stopping. When I finished, I set the document down on my desk and sat very still for a moment. Then I asked Jordan to reschedule my 9 a.m. status conference and close my door. I sat alone in chambers for 22 minutes. I was not thinking about Marcus. I want to be clear about that because I think it matters. I was not thinking about the Sunday dinners or the Instagram photo or the packed bag that had already been in the car before he told me he was leaving. I was thinking about a 71-year-old man from Roswell who had written a check for $410,000 because someone had looked him in the eye and told him it was safe. I was thinking about what it means to be the person in the room with the authority to do something about that. I called my chief judge at 7:51 a.m. I disclosed the new information and its implications for my relationship to the defendant principals. I was thorough. I described the full extent of my personal situation, the separation, the pending divorce proceedings I had quietly initiated the previous week, the nature of my knowledge of the company's operations as a family member by marriage. I told him everything I knew, and everything I felt, and everything I was uncertain about. He listened without interrupting. When I finished, he was quiet for a moment. Then he said, "Schuyler, do you believe you can adjudicate this case fairly?" I thought about that question for exactly as long as it deserved. "Yes," I said. "I do." He said he would take my disclosure under advisement and make a formal determination. He said that if either party filed a recusal motion, the analysis would be different. He said that absent such a motion, and given the nature of my disclosure, he was inclined to let the case proceed with me on the bench contingent on his written determination. His written determination arrived at 4:30 that afternoon. The case would proceed. I read the determination twice. I filed it. I went back to work. What I did not know, what I had no way of knowing that Tuesday morning, was that on the same day I was reading that 43-page filing in chambers, the attorney for Whitfield Premier Development Group was sitting in his office on Peachtree Street reading a document of his own, a standard discovery response, routine paperwork, attached to which was a judicial disclosure form, the form I had filed weeks earlier when the case first landed on my docket, the form that listed my full name, my title, my courtroom assignment, and in the field marked relationship to defendant entity the words, spouse of managing principal. The Honorable Schuyler M. Whitfield. Managing Principal Marcus D. Whitfield. The attorney read it once. Then he read it again. Then he picked up his phone and called Marcus. I know what that conversation sounded like because Marcus called me 40 minutes later at 5:17 p.m. while I was still in chambers reviewing motions. He called from his cell, not the house line. I watched the phone light up on my desk. I watched it ring 4 times. I watched it go to voicemail. He called again at 5:23, again at 5:31. At 5:44, I received a text message. It said, "We need to talk. It's important. Please call me." I looked at the message for a long time. Then I put my phone in my desk drawer and finished my work and left the courthouse at 6:15 and drove home in the dark and made dinner for one and ate it at the kitchen table with a book open in front of me and did not call him back. The case was scheduled for its evidentiary hearing in 6 weeks. 6 weeks was enough time for Marcus to understand slowly and fully exactly who he had been living with. 6 weeks was enough time for him to reconstruct every dinner, every family event, every moment he had watched me stand quietly at the edge of a room and decided I was fine. Just quiet. I hoped he took his time with it. I hoped it kept him up at night. The morning of the hearing, I woke up at 4:58 a.m., not because of an alarm. I haven't needed an alarm in 11 years. My body simply knows when something important is going to happen and decides to be ready before I ask it to be. I lay in the dark for 2 minutes, looking at the ceiling, listening to the particular silence of the house. At that hour, the refrigerator hummed the distant sound of a car on the street below, the way a house sounds when it knows it belongs to one person. Then I got up. I showered. I made coffee. I ate half a piece of toast standing at the kitchen counter because I have learned over years of high-stakes mornings that my stomach does better with something in it than with nothing. I dressed in the clothes I had set out the night before, a dark charcoal suit, white blouse, small gold earrings that had belonged to my grandmother. Nothing performative, nothing chosen for the room I was about to walk into. I had been dressing for that room for 11 years. It required the same thing it always required: clarity. I picked up my robe from the hook behind the study door. I have a specific way of putting it on. Left arm first, then right, then a moment with both hands at the collar to make sure it sits correctly. I learned this from a judge I clerked for, a woman named Honorable Frances Okafor, who had been on the bench for 26 years and who told me on my first day that the robe is not a costume. It's a commitment. Put it on like you mean it every single time. I put it on like I meant it. I arrived at the courthouse at 7:15. The building was already moving security staff clerks, attorneys with rolling bags and coffee cups, and the particular energy of people who have spent the night preparing for something. I said good morning to the security officer at the entrance, a man named Gerald, who had been working that post for 9 years and always had a crossword puzzle folded in his back pocket. He said, "Good morning, Your Honor," and held the door. Jordan was already in chambers when I arrived. He had my docket printed and annotated 2 bottles of water on the desk and a look on his face that I recognized as his version of controlled concern. "Full house today," he said. I said I expected so. He said the plaintiff's counsel had arrived at 7:00. He said the defense team had arrived at 7:08 with 3 attorneys. He said there were 8 members of the public in the gallery already, and a reporter from the Atlanta Business Chronicle who had shown up with a notepad and been reminded that recording devices were not permitted. I said, "Good." Jordan hesitated. In 2 years of working together, he has learned that hesitation costs him more than directness. He said, "The defendant principals are in the building, all 3 of them." I looked at him. "All 3, I said. "Yes, Your Honor. Mr. Marcus Whitfield, Mrs. Diane Whitfield, and Miss Renee Whitfield Carter." I nodded once. I picked up my annotated docket and read through it one more time. Not because I needed to. I had read it so many times I could have recited it from memory, but because reading it one more time was a way of standing inside the case rather than inside the moment. The case was what mattered. The law was what mattered. Every other thing that was about to happen in that room was a consequence of the law, not of my personal history with the people standing inside it. At 9:01 a.m., the bailiff opened the door to the courtroom. I walked in. The room stands when I enter. This is protocol. This is how it has always been. Everyone in the gallery rises, and the attorneys rise, and the parties rise. And there is a moment, a particular suspended moment, that I never take for granted, not after 11 years, not even on routine days, where the room holds itself in a kind of collective attention waiting. I took that moment in. And then I found them. It wasn't intentional. I do not scan the courtroom for familiar faces when I enter, but the human eye, even a disciplined one, goes to the known before the unknown. It is not sentimentality. It is simply how perception works. Diane was in the 2nd row of the gallery behind the defense table. She was wearing a cream blazer I recognized from one of her Sunday dinners. She was sitting very straight the way she always sat, with a posture that communicated that she was a woman of standing and intended for the room to know it. Beside her was Renee, in dark blue, her hands folded in her lap. Marcus was at the defense table. He was looking at me, not the way he had ever looked at me before. Not the look across the dinner table, not the look from the passenger seat, not the look from the bedroom doorway when I came home late from chambers. This was a different look entirely. It was the look of a man who has spent 6 weeks reconstructing every assumption he has ever made, and has arrived finally at the correct understanding too late and too clearly, and with nothing left to do with that understanding except sit with it. I held his gaze for exactly as long as protocol requires a judge to acknowledge the room. Then I sat down. "Be seated," the bailiff said. The room sat. I adjusted the water bottle to my left, set my annotated docket to my right, and looked at the plaintiff's counsel. Sharp, methodical woman named Patricia Osei, who had been practicing federal litigation for 20 years, and had the particular stillness of an attorney who knows her case is strong. "Counsel," I said, "are we ready to proceed?" She said, "Yes, Your Honor." I looked at the defense table. The lead defense attorney, a man named Garrett, who I knew by reputation and had never appeared before me, said, "Yes, Your Honor," with a voice that was almost steady. "Almost." I said, "Then let's begin." From the gallery, I heard a sound. very small. The specific involuntary intake of breath that happens when a person finally understands something they should have understood a long time ago. It came from the direction of Diane Whitfield. I did not look up. I had work to do. The first exhibit entered into evidence was a wire transfer record. $340,000. Originating account, James and Carol Peterman, Marietta, Georgia. Destination account, Whitfield Premier Development Group, LLC operating account. Truist Bank, Atlanta. Date March 14, 2021. Memo line, coming Phase 1 investment. Plaintiff's counsel read the amount into the record without inflection. That's the right way to do it. You let the number speak for itself. $340,000 is not an abstraction. It is a retired school principal's life savings. It is 31 years of work distilled into a wire transfer that took 11 seconds to execute and had not, as of the date of this hearing, been returned. I watched the defense table while the exhibit was being read. Garrett was making notes on a yellow legal pad with the focused efficiency of a man who has accepted that the morning is not going to go well for him and is managing his client's exposure in real time. The two associates flanking him were doing the same. Marcus was looking at the table. Not at me, not at the exhibit. At the surface of the table, in front of him, with the expression of a man trying to locate something solid in a room that has stopped behaving the way rooms are supposed to behave. From the corner of my eye, I was aware of Diane in the gallery. She had stopped sitting straight. Exhibit 2 was the soil report for the Cummings site. Dated January 9, 2021. 2 months before the Petermans' Lanasa wire transfer. The report's executive summary, which plaintiff's counsel read into the record, indicated that the site presented significant subsurface instability, inconsistent with the planned residential development, and that remediation costs would render the project financially non-viable without a complete redesign. Plaintiff's counsel paused after reading that sentence. She didn't need to editorialize. The pause was sufficient. Garrett objected on foundation grounds. I overruled him. The foundation had been established in the pre-trial motions, and he knew it. The objection was for the record, not for the room, and everyone in the room understood that, including him. Exhibit 3 was an email chain, internal, between Marcus and a man identified in the filings as the company's outside financial consultant. Date ranged January through March 2021. The emails had been obtained through discovery after a forensic accounting firm retained by plaintiff's counsel had identified irregularities in the company's document production that suggested selective deletion. A subsequent court order had compelled full production from the company's backed-up server. Plaintiff's counsel did not read the emails in full. She read 4 of them, selectively, with the precision of someone who has tried enough federal cases to understand that more is not always more, and that the right 4 sentences read in the right order in a room that has already been prepared by the exhibits that preceded them can do more work than 40 pages. The first email dated January 22, 2021. Soil report came back bad. Not fixable without numbers we don't have. Don't let this get to the investors yet. The second dated February 3, 2021. Canton denial came through again. 2 for 2. Alpharetta title issue still unresolved. We're going to need to keep the pipeline moving or the whole structure falls. The third dated February 19, 2021. Peterman is ready to wire. Duluth family confirmed for March. Roswell guy is in for 400 plus. Keep the materials clean and the timeline vague. The fourth dated March. First is 2021. Once we have the March wires, we have enough runway to restructure. Get the projections looking right before the Q2 update. Plaintiff's counsel set down the exhibit. The courtroom was very quiet. I looked at the room the way I always look at a room after significant evidence has been entered, not at any one person, but at the overall temperature of the space. The quality of the silence. the way bodies hold themselves when they have just heard something they cannot unhear. The gallery was still. The plaintiff, a woman named Carol Peterman, 67, seated beside her attorney with her hands folded tightly in her lap, and a patience in her face that looked like it had been hard-earned, was looking at the defense table. She had been looking at the defense table for most of the morning with the expression of someone who waited a long time for this room and intended to be present for every minute of it. I looked at Garrett. "Counsel, your response to Exhibits 1 through 7. Garrett stood. He was good. He was genuinely good. A methodical, experienced attorney who knew his way around a federal courtroom and was doing what good attorneys do when the facts are against them, which is argue the law and the process and anything that isn't the facts. He spoke for 12 minutes about the nature of investment risk disclosures, about the distinction between optimistic projections and fraudulent misrepresentation, about the complex regulatory landscape of residential development in the northern suburbs. He was precise. He was composed. He was building the best structure he could with the materials available to him. The materials were not good. When he finished, I asked plaintiff's counsel if she wished to respond. She said yes and spoke for 4 minutes and cited 3 cases by name, 2 of which were mine. I called a 15-minute recess at 11:14 a.m. The room rose as I stood. I walked to the door behind the bench. Before I reached it, I heard from the gallery a low voice. Diane's voice, taut and careful, directed at someone beside her. She said, "That's Marcus's wife." Not was, not used to be, present tense, wife. I heard Renee respond. Quiet. 3 words I didn't catch. Then I was through the door and in the corridor behind the bench, and the door had closed, and I was alone. I stood in the corridor for 90 seconds. I thought about nothing in particular. I looked at the wall. I listened to the building. Somewhere in the distance, a printer was running. A phone rang twice and stopped. The ordinary sounds of a building full of people doing consequential work. Then I went back in. The afternoon session began with Garrett requesting a brief continuance to allow the defense additional time to respond to the supplemental evidence. I denied the request. The supplemental evidence had been filed within the timeline established by the pre-trial scheduling order. Both parties had had adequate time to prepare. Garrett accepted the denial without argument. The afternoon moved through 3 more witnesses. A forensic accountant who walked the room through the wire transfer structure with the methodical patience of someone who had explained complex financial fraud to juries for 20 years. A former Whitfield Premier employee who had left the company in May 2021 and had submitted a declaration describing internal discussions about investor communications that she had found troubling enough to document at the time. And James Peterman himself, 71 years old, a former mechanical engineer from Roswell with large, careful hands and a blue suit that looked like it had been pressed that morning, who described in a voice that did not waver the conversation in which a Whitfield Premier representative had assured him that the investment was as close to guaranteed as anything in the private market. He said the word guaranteed. He said it the way people say words that were said to them with the exact weight the word had carried, at the time the weight that had made him write the check. When plaintiff's counsel finished with him, she sat down. Garrett cross-examined for 11 minutes. James Peterman did not waver on a single point. When Peterman stepped down, I looked at the clock. 4:47 p.m., I looked at the room. Marcus was no longer looking at the table. He was looking at me, not with anger that would have been easier to read, with something more complicated, something that had started as disbelief and moved through shock, and arrived over the course of 8 hours in this room at a kind of reckoning. The particular expression of a man who has spent a day watching the architecture of his own choices being examined under fluorescent light by people who are very good at their jobs. I held his gaze for 1 second. Then I looked at counsel table. "We'll resume at 9 a.m. tomorrow for closing arguments," I said. Court is adjourned. The room rose. I stood and walked to the door behind the bench and did not look back. In the corridor, I stopped and stood very still and listened to the sound of the courtroom emptying on the other side of the wall, the shuffle of papers, the rolling of bags, the low, urgent voice of Garrett already talking to his associates, the sound of the gallery clearing. And then distinctly through the wall, I heard Marcus's voice. Not the words, just the sound of it. The particular register of a man who is asking a question he already knows the answer to. I walked back to Chambers. Jordan was at his desk. He looked up and said nothing which was exactly right. I sat down. I opened the next file on my docket. I had work to do. The closing arguments took 2 hours and 14 minutes. Plaintiff's counsel went first. She was precise and unhurried the way you can afford to be when the evidence has done most of the work already. She walked the room through the timeline one final time, not to introduce anything new, but to make sure that by the time she sat down, the shape of what had happened was so clear and so complete that no amount of reframing could alter it. She ended with James Peterman. Not his testimony, just his name and the number. $410,000. She said it once and sat down. Garrett went second. He was better in closing than he had been during the evidentiary session which I had expected. Closing is where good attorneys find their register. He argued investment risk. He argued the complexity of the development landscape in post-pandemic Georgia. He argued that optimism is not fraud, and that failed projects are not inherently evidence of intent to deceive. He was careful and thorough, and he built the best structure he could. It was not enough. He knew it was not enough, but he built it anyway, because that is what good attorneys do, and I respected him for it. I took the matter under submission. I did not issue a ruling from the bench. That is not my practice. I take complex civil matters under advisement. I write. I reason on paper. I issue a written opinion that can be read and understood, and if necessary appealed by people who were not in the room. That is how I have always worked. Not because I'm uncertain, but because the reasoning matters as much as the conclusion, and the reasoning deserves to be done properly. The written opinion took me 9 days. During those 9 days, the world outside the opinion continued to move. Marcus called 7 times in the first 3 days after the hearing. I did not answer. He left 2 voicemails. The first one was long. I could tell by the counter before I deleted it without listening. The second one was short, 22 seconds. I deleted that one too. Not out of cruelty, out of the simple understanding that there was nothing in those messages that could be relevant to anything I needed to do. On the 4th day after the hearing, Patricia, my financial advisor, called to tell me that a joint account Marcus and I had maintained for household expenses had seen an unusual withdrawal. $47,000. Marcus had been a signatory on the account. He was legally entitled to make the withdrawal. Patricia flagged it because that is what Patricia does. I thanked her. I noted it. I called my attorney. My attorney, whose name is Vivienne, and who has practiced family law in Atlanta for 22 years, and has seen every configuration of marital dissolution that this city can produce. Said the withdrawal was aggressive but not uncommon in separations where one party begins to feel their financial position shifting. She said we had options. She said we should move quickly on a few things. We moved quickly. On the 6th day after the hearing, the Atlanta Business Chronicle published a piece. It was not about the case coverage of pending federal litigation, is constrained in ways that reporters understand, but it was adjacent to it. A business reporter had been tracking the Whitfield Premier Development Group story since the case had been filed, had spoken to several investors, and had written a piece about the broader pattern of development fraud in the northern Atlanta suburbs. The piece did not name me. It named the company. It named the principals. It ran on the front page of the business section with a photograph of the Alpharetta site. A flat, unremarkable piece of land with a faded rendering banner still standing at its edge. The kind of rendering that shows gleaming buildings and happy families and a future that was never going to exist. Renee called Marcus that morning. I know because he called me 40 minutes after the piece ran at 7:22 a.m. in a voice that had shed whatever remained of its composure. I did not answer. The piece was shared 847 times on LinkedIn by the end of the day. Several of those shares came from people in Atlanta's real estate and investment community, the community where the Whitfield name had meant something, had carried weight, had opened rooms. The comments were not kind. On the 8th day, Diane Whitfield called me directly. I answered. I don't know exactly why. Perhaps because there was a part of me that wanted to hear what she would say when there was nothing left to perform for. She said my name. She said it the way people say names when they are not sure the person on the other end will stay on the line. I said, "Hello, Diane." There was a pause. Then she said she wanted me to know that she had never meant, and here she stopped. She started again. She said that she had always thought I was, and stopped again. A third time, she said she hoped that whatever happened with the case, I would know that as far as she was concerned, I waited. She didn't finish the sentence. I said, "I appreciate you calling Diane." She said, "I didn't know what you did. Marcus, never, we didn't know." I said, "I know." She said, "Would it have mattered if we had known?" It was the most honest question she had ever asked me. In 4 years of dinners and holidays and Sunday afternoons in her Buckhead house, it was the first time she had asked me something real. I thought about it. I gave it the consideration it deserved. "I think it might have," I said. "And that's exactly why I didn't tell you." She was quiet for a long time. Then she said, "That's fair." I said goodbye. I hung up. I sat at my kitchen table for a moment with my hand still on the phone. Outside the window, Atlanta was doing what Atlanta always does in February, overcast. Tentative the trees, not yet sure if winter is finished with them. I looked at the street for a while. A woman walked past with a dog. A delivery truck idled at the curb. Ordinary life moving at its ordinary pace, indifferent to the things that had been happening in my house and my courtroom and the spaces in between. On the 9th day, I finished the opinion. 61 pages. Findings of fact, conclusions of law analysis and determination. I read it twice. I made 7 small revisions. I read it a third time. Then I signed it. The opinion found in favor of the plaintiff on all substantive counts. It found that the defendants had engaged in a pattern of fraudulent misrepresentation in the solicitation of investment funds, that the misrepresentations were material, that they were made with knowledge of their falsity, and that investors had reasonably relied on them to their detriment. It ordered the disgorgement of all investor funds with interest. It referred the matter to the U.S. Attorney's Office for consideration of criminal referral. It imposed joint and several liability on the individual principals of Whitfield Premier Development Group, LLC. The individual principals were Marcus D. Whitfield, Diane Whitfield, and Renee Whitfield Carter. The opinion was docketed at 3:47 p.m. on a Thursday. By 4:15, it had been served on all parties. By 4:52, I received a message from Vivian, telling me that Marcus's attorney had called her office within 20 minutes of service. She said his attorney sounded like a man who had spent the last 9 days hoping for a different outcome and had just received confirmation that hope was not a legal strategy. Vivian said, "You doing okay?" I said yes. She said, "The asset freeze motion will be filed by end of day tomorrow. His personal accounts, the business accounts, everything tied to the entity. Standard post-judgment procedure." I said, "Thank you, Vivian." I put down the phone. I sat in my study for a while in the quiet. The house was the way I had come to prefer its still organized mine. No performance required, no version of myself maintained for an audience. Just the actual dimensions of the life I had built, which were, it turned out, considerable. The Buckhead house sold 8 weeks later. I read about it in a property records search I had no professional reason to conduct, and every human reason to conduct. $2.1 million. Sold under pressure, Vivian's paralegal noted at $340,000 below the assessed value. Diane had moved to a condominium in Sandy Springs. Renee had retained separate counsel. Marcus had moved somewhere I didn't know and didn't need to know. Amber, as far as I could determine, had moved on. That part at least surprised no one. 6 months after the opinion was filed, I went back to Savannah. Not for a case, not for a conference. Just for a weekend alone, the way I used to go before Marcus, before the bench, before I became a person with a title that arrived in rooms before I did. I drove down on a Friday evening with the windows down and the radio on a station that played old soul music and didn't talk much between songs. The drive is 4 hours. I didn't stop. My mother lives in the same house I grew up in, on a street that has changed around it without quite changing it. New families, new paint on the neighboring houses, a coffee shop where the hardware store used to be, but the house itself is the same white clapboard with the green shutters and the porch swing that my father installed in 1987, and that my mother has repaired 4 times since but never replaced. I pulled into the driveway at 9:41 p.m. The porch light was on. It is always on when I'm coming. She was waiting in the kitchen with food on the stove. My mother is 71 years old and has the particular quality of women who have survived considerable things without making their survival a performance. She hugged me at the door the way she always hugs me, fully without reservation. The kind of embrace that doesn't ask you to explain yourself before it lets you in. She smelled like the shea butter she has used my entire life, and the specific warmth of a kitchen where something has been simmering for hours. She said, "You look tired." I said, "I know." She said, "Sit down." I sat down. She put a bowl of soup in front of me and sat across the table and didn't ask me anything. That's one of the things I love most about my mother. She understands that there is a time for questions and a time for soup, and she has never confused the two. I ate. She watched. After a while, she said, "You want to talk about it, or you want to just be here?" I thought about that. "Just be here," I said. "For now." She nodded. She got up and refilled my bowl without being asked. We stayed at that table until nearly midnight, talking about nothing consequential, her neighbor's new fence, a book club. She had joined at the library, a cousin in Brunswick who had finally gone back to school at 54 and was apparently thriving. Ordinary things. The texture of a life that moves at human pace, unbothered by the large and consequential machinery of federal courts and asset freezes and 61-page opinions. I slept for 9 hours that night. I don't remember the last time I slept for 9 hours. In the morning, I walked to the river. Savannah in early summer is a particular kind of beautiful, heavy and green, the air thick with something that isn't quite humidity and isn't quite warmth, but is the specific combination of both that means home to anyone who grew up in it. I walked the route I had walked as a child, past the squares through the historic district down to the riverfront, where the water moves slow and brown and indifferent to the city it has been running through for 3 centuries. I stood at the railing and looked at the water for a long time. I thought about the night I met Marcus, and the $34 dress, and what I had wanted from that evening, just one night of being a person and not a position. I had gotten that. What I hadn't accounted for was that the person and the position were not actually separable. That you cannot take off what you are like a coat you wear for work. That the same mind that watches a room for patterns and builds cases from evidence and waits for the right moment to act is not a professional skill that clocks out on weekends. It is simply who I am. It is how I was made, or how I made myself, or some combination of the two that I have long since stopped trying to untangle. I had wanted Marcus to choose me without the title. He had. He just hadn't understood what came with the choice. That was not entirely his failure. I had kept things from him, not the title, not the courtroom, but the fullness of what I was. I had given him the quiet version and withheld the rest, because I was afraid that the rest would change the equation before I knew whether the equation was worth protecting. That fear was understandable. It was also, in the end, a kind of diminishment, not of him, of myself. I had spent 3 years being fine, just quiet, and the whole time the robe had been hanging on the back of my study door. I stayed at the railing until a tourist boat moved past on the river, slow and white against the brown water, someone on the deck taking a photograph of the skyline. I watched it go. Then I turned and walked back through the squares toward my mother's house. On the walk back, I thought about what I wanted the next part to look like, not the next case, not the next motion, or the next docket, or the next opinion. The next part of the life beneath the work, the part that happens in kitchens and on long drives and at tables where the food has been simmering for hours. I thought about what it would mean to let someone into the full version of me from the beginning, not the managed version, not the version calibrated to avoid the particular kind of disappointment that comes from being too much for a room, just the actual version, all of it, from the start. That felt like the right direction. It felt for the first time in a long time like something I was genuinely looking forward to. My mother was on the porch swing when I got back. She had 2 glasses of iced tea and a paperback she'd already read twice, because she said good books deserved at least 3 visits. I sat down beside her, and she handed me the tea. And we swung in the particular easy silence of people who have known each other long enough that silence is its own kind of conversation. After a while, she said, "You seem better." I said, "I think I am." She said, "Good." She opened her book. Then, without looking up, she said, "I always knew you were going to be fine. I just knew it was going to take the exact right amount of time." I looked out at the street. A child rode a bicycle past the house, wobbling slightly, figuring out the balance. I drank my tea. I thought, she's right. It took exactly as long as it needed to. Not a minute more. The robe was always mine. I just hadn't needed to wear it in front of them. Until I did. If there's something I want you to take from this, not a lesson, because I don't believe life hands out lessons so much as it hands out information and leaves you to decide what to do with it. It's this: the parts of yourself you protect most carefully are not weaknesses. They are often your greatest sources of power. The question is not whether to reveal them. The question is when and to whom and under what circumstances. I revealed mine in a federal courtroom in a robe that had been mine for 11 years to a room full of people who had spent years deciding I was small. I don't recommend waiting that long. But I understand why some of us do. Take care of yourself. Take care of your people. And if someone tells you that you're fine, just quiet let them think so, for now.